Hello everyone, my name is Lesley Smith and I'm a director of Bowcock Cuerden LLP. This vlog is about the importance of employees having a written contract of employment. Employers are obliged to provide written particulars of employment under the Employment Rights Act. Aside from the statutory obligation, it's important to have a written contract as that will define the rights and obligations of the parties, and there should then be no dispute over the terms that have been agreed. If there's no written contract, it would be a mistake to think there is no contract. In that case, there will be an oral contract of employment. That's less satisfactory, as firstly the employer will be in breach of legislation to provide written particulars of employment, and secondly, it's likely that the position regarding the employee's terms and conditions will be less clear-cut, and there could be room for dispute in the future. Now, the contract needs to include, amongst other things, clauses relating to the job the employee is required to do. It's important to set out what is required of the employee, giving yourself flexibility so that your business needs are met. The notice periods you and the employee are required to give, which are subject to statutory minimum periods of notice. The employee's place of work, you should consider what, if any, flexibility you need here. The employee's hours of work, you should consider whether the employee needs to sign an opt-out, which would allow them to work more than, on average, 48 hours a week. You need to include terms relating to the employee's remuneration and how they're paid. Bear in mind employers have to pay certain minimum wage rates. You need to include terms related to holidays, holiday pay, sickness, sick pay and pensions. Again, there are certain minimum obligations there. And you also need to include terms relating to disciplinary and grievance procedures. Aside from the terms you have to include, you can tailor the contract to meet your business needs. Each business is different, but we find that many think it's useful to include clauses relating to a probationary period, which governs the start of the relationship, the right to vary the contract, clauses relating to confidentiality in your business information, the need to take care of employers' property, the need for a driving licence if that's relevant for the employee's job, what happens in relation to any training costs you've incurred on the employee's behalf if they leave your employment, and terms relating to telephone and social media use, which are very relevant today, and in appropriate cases, terms that seek to restrict the employee's conduct after they leave your employment. So it's a complex area. If you require any further information, please contact us on 01270 611 06. Thank you very much for listening.